Welcome everybody to our third live stream of lockdown 2021. Today we're going to be covering on contractual obligations under COVID-19. My name is Mark Skelly. I'm the President and Acting CEO of the Hutt Valley Chamber of Commerce, and I'm very pleased today to have Rhys Williams, partner from Gibson Sheat, with us. Today is all about getting ahead, as our theme has been all week. Preparing for what may occur should our lockdown go further, and the economic impact of that digs in deeper. And if you're already in that situation now, what are the things you need to be starting to think about? Look, we're very pleased to be working with Gibson Sheat today for this live stream. Gibson Sheat are a platinum partner of the Chamber of Commerce. They've got a very long history here in the Hutt Valley, and now are based in the Hutt, in Wellington, and also in the Wairarapa. Their team have a really wide knowledge across a huge range of legal subjects, from property, personal law, litigation, rural, business, employment. So they're the perfect partners to be working with us on this. And from personal experience working with a number of their team over the years, they're just superb. They do a great job. They're very personalised, and Rhys, I can say that they're surprisingly human. For lawyers, they talk in English and they make sure their clients understand, and that's certainly been my experience in all my dealings with them. Rhys is going to talk today about the contractual obligations, particularly under COVID. We're going to focus on commercial leases, as that's an area that a number of people have been asking about and thinking about. Obviously, last lockdown, there were a lot of changes and rent relief situations occurring. So this is a little bit different this time. And Rhys is going to talk to that. He's also going to look at what the other OPEX relief options that are available, how to go about doing that, and what might change as we move down alert levels. Hopefully we'll provide some clarity to the questions that we were getting asked online and our FAQs the last few days. And as always, through the live stream, jump onto Facebook, stick in your comments and questions, and we'll try and address those at the end. So that's all for me right now. I'm going to hand across to Rhys, Rhys Williams from Gibson Sheat. Thank you.
Thanks, Mark, and morning, everyone. I certainly didn't see us sitting here even a couple of weeks ago. 2021 was going pretty well for all of us, but I guess it's a pretty quick reminder that things can change really quickly in this environment, and we're back to a scenario we were in April last year. We've now got the benefit of having had over a year of experience with this. So we've got the benefit of that hindsight now. So today I thought I would just sort of run you through briefly what the legal position is in relation to contracts in these unexpected lockdowns. And as Mark said, with a particular focus on leases. So in law, there is very limited help outside of the contract for a lockdown scenario. There can be arguments that people can raise in relation to what's called frustration of contract, where a contract is impossible to perform, or it's radically different from that was contemplated when the contract was entered into. Courts are very reluctant to grant this kind of relief. It's a very high threshold, and I'm not aware of any frustration type arguments prevailing that tenants have raised. So unfortunately, that's not much help to us. So if we step outside the legal framework that we operate in, and then we now look at the agreements that we might have in place, sometimes agreements have what's called a force majeure clause in them. And that's a Latin phrase for a provision which says if for reasons outside your control you're no longer to comply with your obligations, even for a short period of time, then you'll get some relief. So your obligations will be suspended until you can continue to perform. And in some cases, force majeure says that the contract ends, for instance, after say a month or of these things outside your control occurring. So Again, it's something that you won't see in every contract, but they are there, and we have been putting pandemics as events which will trigger those in the last year, but they are being read pretty strictly by courts. So it's probably, it's not necessarily something you'd want to hang your hat on, and you certainly would want to seek legal advice before you sort of took any step to rely on something like a force majeure provision. So that brings you, if you kind of look at those scenarios and then you think, well, what else might I be able to do? Often it's really good to go back to basics. So thinking about, actually, can I just bring this contract to an end? And often contracts are for a defined period of time, and then they go into sort of a rollover scenario where either party can bring the contract to an end by a period of notice. And that also applies to leases, which I'm going to talk about shortly. And in the case of a lease, often it's if the lease is rolled over, it's a period of 20 working days. You can give notice, and the lease is at an end. So that's kind of, if all else fails, that's kind of where you look to make sure that you actually you're not locked in for a period of time, and you sometimes can bring them to an end. Unfortunately, COVID-19, the general position, it is evolving slightly, is not something that is captured by a business interruption insurance policy. So that's not much help to us either. So we can't look to insurance like we normally would for these kinds of unexpected events that we didn't cause. There are specific types of contracts that I'm not going to talk about today, but that are certainly relevant and have their own sort of legal framework. One of them is construction contracts. And under the Construction Contracts Act, there is a specific regime that deals with contracts and applies terms into all construction contracts. That is something that we have a specialist construction team that operate in that space. And I certainly recommend that you, if you have got any concerns about your contractual obligations during this time, that you get in touch with me. My details will be available through the chamber, and I can put you onto one of our construction experts. The other thing that you're probably thinking about, along with leases, particularly for smaller businesses, how am I going to deal with employment issues? Because you'll have all sorts of employment questions about how do I deal with things. Again, we have got a lot of resources on our website and articles, and it's not an area I'm going to cover off today because it is a specialist area, and I'm the first to admit I'm not an employment lawyer. There also is the Employment New Zealand website, which has a Q&A section for some really commonly asked questions. So as Mark was saying, it's really good to reach out to these organisations at this sort of time when it's really hard for us, and just seek advice from your accountant or your lawyer or some of these, the chamber or these other organisations. Leases are a point that I really want to cover off today, because I know that it's a major cost for many businesses, and I'm just going to look at it from the perspective of the tenant. There's obviously two sides to the equation, but we're just looking at it from a tenant's perspective. Now there's nothing in the law, so to speak, or the government has certainly indicated they're not prepared to get involved in addressing these, the fairness aspect around rent relief and OPEX relief during these lockdowns. So you really have to look to what is in the lease and whether that allows you to get any sort of a rent-free period for a period of time. So what happens, the most commonly used lease in New Zealand is called the Auckland District Law Society lease. And after the 2011 earthquakes in Christchurch, there was a provision added dealing with red zone properties that businesses couldn't access, not because there wasn't anything wrong with them, but just because they were in the red zone cordon, which allowed tenants relief in that situation. And fortunately, that clause was drafted wide enough to deal with emergencies and pandemics like we're facing at the moment. So the question for you as a business owner or a tenant is whether your lease has a clause 27.5, and it's likely if you did sign up to your lease post 2011, it will have one of those clauses in it. But if it was pre 2011 that your lease started, it won't have that in it, and you'll have to try and negotiate with your landlord in good faith outside of any legal avenue. And I'll talk about that very briefly at the end. So clause 27.5, what does it actually say? So it says if there's an emergency, and we are currently in the government has declared a state of emergency, which started in March last year and has continued and continues to this day, and the tenant is unable to gain access to their premises to fully conduct their business because of reasons of safety of the public or the property, then a fair proportion of rent and outgoings ceases to be payable for the period starting when the tenant was unable to gain access to the premises to fully conduct the tenant's business and ending when that inability ceases. So there's a this clause, it's important to remember, it covers rent as well as operating expenses or outgoings as the lease refers to them. So it covers both of those things. So the lockdown is certainly a scenario where this clause applies. Certainly at level 4 and level 3, and I'll talk about level 2 a little bit later. So if you have 27.5 and you've got one of these leases, you're certainly entitled to some sort of relief. Now, the tricky thing is it talks about a fair proportion of rent ceasing to be payable, and that's a little bit like how long's a piece of string. There are some things that we think about. So the first thing is that by its very nature, a proportion of rent that ceases to be payable means that you have to pay something. You can't just say, I can't operate my business, so I've got no revenue, so I'm not going to pay you anything. That's not how this works. So it's something greater than zero and something less than 100 is the starting position. There's a whole lot of factors that need to be taken into account. So, and I guess before I sort of go through these, it's important to realise that some businesses can still operate at level 4. So if you're an essential service and you still can operate, then you won't have any recourse under this because particularly if you've got absolutely no disruption to your premises, that this clause doesn't apply because you can access the premises and fully conduct your business. If you are an essential service and you have some limits or you're only conducting part of your business, then certainly you'll still be able to seek some relief in relation to those parts you can still conduct. So that's just an important point that I just wanted to cover off. So some of the other factors we look at is whether the premises is still being used. So, for instance, often, we were all up and left. We were told at sort of 4 o'clock in the afternoon that we were being locked down at midnight, and so everyone was up. We might have got into work in the evening to pick up some things or to deal with things that need to be dealt with. But by and large, we haven't been back there, and all that stuff's still there. So the premises is still being used. Sometimes people are working remotely, accessing their computer services are on the premises, or people have storage facilities at their premises. So the extent to which it's still being used is relevant. Can the business continue? So a lot of businesses can't continue because they need to be at work to operate their business. An obvious one is a restaurant or a cafe at level 4. But some businesses can continue, like, for instance, our business can continue remotely, and lots of other businesses can as well. So that's a relevant consideration. I guess the financial aspect as well is worth taking into account. So if those of you that are tuning in today haven't looked at what support's available to you, I know most of you will be aware of the wage subsidy, but there's also the COVID resurgence payment that's available as well. I think that the Chamber's previously run sessions on this. That's something that's depending on whether the landlord has a business, may not necessarily be available to the landlord, but it certainly will be available to a tenant if the criteria are met. And then the other thing that needs to be taken into account is, landlords costs. So if you take sort of an office environment, you've got a landlord that will have staff, often if they're of a size, that need to manage the properties. They'll have security. They obviously have to keep the property secure. They'll have services in the buildings that, air conditioning or heating or refrigeration. They need to keep going. And they've obviously things like rates, they don't go away. So, there are costs that a landlord is incurring while this is happening. So they're kind of some of the things that are taken into account when deciding whether it's fair, to reduce the rent. So I sort of thought it would be helpful. I canvassed our team before speaking today about what we've seen in the trenches in terms of what sort of percentages are being offered to businesses. And there's certainly some themes coming out of it. So retail businesses, we're seeing between sort of 50 and 80% rent relief, particularly, retail that, obviously I'm talking here about non-essential retail, but certainly more than 50 and sort of up to 80. We are seeing some landlords that have very long-standing relationships with their tenants offering 100% relief. So we have seen that as well, but that's obviously the landlords there are going above and beyond their legal obligations, and probably with a view to, taking a really long-term view of things, which is something that if the parties are in a position to do is great, because this is hopefully a short-term predicament we're in, and we're going to live to see another day. In the office space, 50% would be customary. We haven't seen tenants being refused less than 50%, but 50% is almost a very customary figure for office space. Hospitality would be more than 50% in every instance. Again, probably more similar to retail, up to that sort of 80% level. So that's kind of what we're sort of seeing. And as we move back down the alert levels, obviously level 4 is the most restrictive environment, but level 3 as well will still be very restrictive for us. And we won't be able to fully conduct our businesses often. So again, you'll be entitled to some relief under the lease for your rent and outgoings, but it will certainly be a lesser percentage if you can conduct some part of your business from the premises. And then again at level 2 as well, I know particularly for in hospitality businesses with the social distancing requirements mean that you can't serve as many customers as you would have normally. That will also entitle you to some sort of rent relief. As I was mentioning earlier, we have had the benefit of a year since the lockdown, when we were kind of all scrambling to figure out what this all meant in terms of the lease. And there has been, we thought there might have been more case law or law coming out of the courts on this, but there hasn't been a lot. There was one case where a landlord of sort of a large commercial premises in Hamilton that had the IRD as their anchor tenant, and they had a cafe in there in the ground floor. There was a dispute as to payment of rent, and the cafe just flatly refused to pay rent right through the alert levels at 2 and 1 as well. And what the landlord did was actually issue a statutory demand, which is kind of effectively threatened to place this company into liquidation unless they paid the rent that the landlord claimed they were owed. Now that case has never been decided. There was an application to set aside the statutory demand filed, and it was heard by the High Court. And while it wasn't sort of the point about what is a fair proportion of rent wasn't sort of concluded by the court, or there was no sort of factors given. There was some observations made by the court, and it was really interesting. And this probably case stands a little bit on its own facts, but it was, what happened was the IRD, as you'll be aware, said that our staff are to work from home if they can. And the difficulty the cafe had was that it had an obligation in its lease to be open between a set, for a period of time between 9 and 5 each day, obviously to serve IRD employees their daily flat white. So there were quite restrictive arrangements on the cafe, and what the court actually said was the fact that that there was these obligations to keep the business open, and the IRD had effectively made a declaration that impacted on their custom of the cafe. That meant that there was more relief available to the cafe, because they weren't they'd lost some custom because they couldn't fully conduct their business. So it's really important in that 27.5, the court is really looking for a business to be able to fully conduct, and if there's circumstances that impact on the custom, then they're certainly looking to grant some relief in those circumstances. So that was really interesting. I think going back to the Christchurch scenario, this clause is about the premises, and here the court is sort of probably interpreting more in favour of the tenant and looking at its impact on its revenue. So I think perhaps in light of that, some arguments that people might have about, well, my tenant is a professional organisation and they can operate from home, and they're, why should I suffer, I don't know, a 50% reduction in my revenue when their revenue might only be going down by 10%. So I certainly think that this case is just the observations of the court are opening the door for, for tenants to kind of argue more forcefully about that position. The other case, which is quite interesting, is a dispute tribunal case, and I'm sort of going to talk about that a little bit shortly. That was a case where it wasn't for a whole lot of money. It was only sort of about sort of $7,000, compared to this coffee case that I'd been speaking to, which was about $40,000. And in that case, it was a sort of a professional services firm which could operate from home, and the disputes tribunal said, actually sort of sided with the landlord, and said, you're only entitled, the business was only entitled to a 20% reduction in the rent. So again, quite interesting to see, that the courts are sort of looking outside the premises, which is, how a lot of lawyers looked at 27.5 last year, and are taking a really wide set of factors into the fairness argument, which I guess is probably, if you're thinking about fairness, that's probably appropriate. There are we are aware of other circumstances where leases don't have this clause 27.5, or there's no relief available. And I know certainly there's situations in places like Queenstown where, the other places like Rotorua, where tourism business have really been struggling, not just in lockdown, but out of lockdown as well because of the borders. And we are seeing landlords and tenants agree on turnover rent. And I quite like that from a conceptual perspective, because both parties are sharing the loss in revenue. So for instance, if a tenant's revenue compared with the same period last year was, I don't know, say 30% down, then their rent would be 30% down, and obviously the landlord again's his or her rental is down by 30% as well. So that there's kind of, I guess, there's an element of kind of fairness there. So we certainly are seeing those kind of more creative arrangements being struck as well. If you get to a point where you just can't agree with the landlord, and that may well be the case. The government's actually given tenants a little bit more time to try and reach agreement. So before lockdown last year, if you were late in paying your rent, the landlord could serve a Property Law Act notice giving you 10 days to pay up. Otherwise, they would end your lease. That period has been extended to 30 working days. So it just gives you a little bit more time to sort things out. And even if the landlord does cancel your lease after those 30 working days because you haven't paid the rent, there are still avenues for you to try and get the lease back. It's known as relief against forfeiture. So it's kind of it's what's called an equitable remedy. So it's not there's no sort of set rules around it, but it is certainly something that you could look if that had happened to you and you were able to kind of bring arrears up and get your lease back. And it is certainly a risk for landlords when they are cancelling. If they don't sort of if they release the premises, it's certainly a risk for them that they don't, they need to cover that aspect off and their new agreements lease with the new tenant. So again, if you can't reach agreement with the landlord, in the lease it says that, and I'm talking here about the ADLS lease, that you need to try and agree first, and if possible mediate, and then if the parties can't agree within 30 days, then the matter goes to arbitration. Now, arbitration is kind of it's an abbreviated court process, and it often can be as expensive as court proceedings. So it's, unless we're talking about big sums of money, it's often not that attractive for people. So there are helpfully other avenues that are available to businesses for sort of smaller sums. And the first one is the Auckland District Law Society Property Disputes Committee. So if the tenant and landlord both agree to refer a dispute to that committee, which is a committee of experienced property lawyers, they kind of meet and they hear the dispute on the papers. So it has to be referred by lawyers for the landlord and tenant, so you can't go there directly yourself. And there has to be an agreed set of facts, and then they determine the matter on what's called on the papers. So there's no sort of oral arguments. It's just they look at what's been put in front of them and they make a ruling. And so the parties will need to pay their own legal costs to do that. But helpfully the cost is only $100 each for the parties in terms of the Auckland District Law Society costs of making the ruling. So that is, that's quite a good option for people to have more of an abbreviated, less formal process to resolve disputes. The other forum that is being used for disputes is the Disputes Tribunal, and the Disputes Tribunal Act actually has a provision which says that the Disputes Tribunal has jurisdiction over matters, even if an agreement is says it doesn't, and even if there is an arbitration provision in an agreement, which there is in a lease. So again, we're seeing, I mentioned that case earlier about people going to the Disputes Tribunal. It's kind of it's a little bit of a lottery, I have to admit. There's not necessarily a whole lot of legal rigor in that process, but if we're not talking about a lot of money, it can be an affordable way for people to deal with it. So you just need to be aware that disputes have to be less than $30,000 to go to the Disputes Tribunal. If the amount the landlord's claiming is more than $30,000, they can't use the Disputes Tribunal. But equally, they could look to reduce that claim to less than $30,000 to get it within that jurisdiction. So yeah, there's a couple of options there for resolving the dispute if your landlord just won't agree to what's fair. Again, in terms of timing of when you might seek this, so customarily rent is paid in advance, monthly in advance, And so, we're for the period in lockdown we're currently in, it would have been paid on the 1st of August customarily. So obviously you've paid all of your rent for this month. If you can come to an agreement with the landlord on what's fair, then you would deduct an amount for next month. And it's preferable that you record in writing, even if it's just by email, what that agreement is in terms of the fair reduction and the period it covers. And I think, if you can't reach agreement with the landlord, it'd be a really good idea for you to pay what you thought was fair going forward, even if it wasn't resolved, rather than just doing nothing. I think that would be the preferable approach. So I've talked about the Auckland District Law Society lease a lot. That's obviously the most commonly used one. There are other leases floating around as well. The Property Law Council leases is another one that is more landlord friendly. That one only provides relief to tenants for matters where the landlord's insured. And as I was mentioning before, unfortunately, pandemics are excluded from sort of most landlords' commercial rent insurance policies. So that's not usually going to be helpful. The other common lease that we see, for instance, in Queensgate, the mall leases, they typically don't allow for any rent relief in this scenario. They only allow for rent relief in a damage scenario where the premises has been damaged. So again, not super helpful, but certainly what we have seen is, people acting in good faith, really, and taking a long-term view. So despite the fact that the landlord might be able to recover all of the rent and outgoings over this period, often we're seeing them kind of, take a more kind of accommodating approach and offering some sort of relief. So hopefully that was helpful, and that's it from me. So I'll pass myself back over to Mark.
Hey, thanks so much, Rhys. You really went into a lot of detail there. I know that people are already commenting online that was really helpful. So thank you so much for doing that. Hey, look, you made some really good points around the fact that landlords are businesses too, and it's really important we remember that it's all well and good as a tenant that we may have some problems, but the landlord may have some challenges as well. So respecting that is a really important part of the process, right?
100%, yeah.
Yeah. Look, you made a couple of things I thought was really, really useful. One was the point you made around if you can reach an agreement informally, to make sure you document that in writing, even if it was an email. I think that was a really good point. I know that lots of people think they're going to remember what happened, but try and remember 8, 9, 10 months ago what an agreement was. Memories tend to fade a bit, don't they? So email is a really tangible, really good idea. And also the point about paying something that you think is fair if you can't reach an agreement, rather than just doing the hard line, I'll pay nothing tactic, which tends to backfire in most cases, doesn't it? So yeah, it was really good advice.
Yeah, and I think it's it's, you'd like to think that the relationship with landlord and tenant is sort of it's you're going to need a favor from your landlord at some point, right? I don't know, there might be something, something goes to the window, or you need something quickly, and I think if you kind of, you might not always agree with someone, but at least if you can, I think it'd be hard for them to say you're being unreasonable if you paid what you thought was fair.
Yeah, absolutely. So Rhys, one question: how would you recommend somebody start this conversation with their landlord? Would you suggest talking to their legal advisor first to get a grip on the situation? Just reach out by email or phone to the landlord directly and start there? What would you suggest?
The first thing I think you need to do is understand your legal position. So whether you have got, one of these leases with a clause 27.5, because I think if you don't have that in your lease, you need to tread quite carefully and be a bit more, kind of at least legalistic, at least, I guess, if you like. So just wanting to kind of, we're all in this together, we're sort of drawing on some of that team of 5 million stuff, and sort of just trying to say, look, we're doing it tough, and probably a little bit of a sob story would be the approach. If you do have a 27.5, look, I probably would, you're in a negotiation, you always sort of start as high as you can without offending someone, right? So that's typically, the position we'd take. But I guess, certainly if we're talking quite a big sum, you might want to talk to someone like ourselves to kind of give you some factors or some ammunition to put to the landlord. But if we're hopefully Wellington's looking in pretty good shape. We might, get down the levels, who knows, but, we might not be in as long a lockdown, I certainly don't think, as Auckland. So the pain might not be quite as hard this time as it was in April last year.
Yeah.
So,
fingers crossed, that's for sure.
Yeah, and hopefully the people that are tuning in today can sort of take, I've given some examples of sort of what we're seeing in some of those sectors. One thing I did forget to cover off was warehouse type scenarios where you might have somewhere down in Seaview, which is a warehouse or something like that. I would expect probably, the landlord to get probably you not have to give a whole lot of rent relief in that scenario, because really the premise, other than not being able to access, is that the main purpose is to store things.
Yeah.
So I think again, just understand your legal position. Just in response to your question, Mark, understand your legal position before you go to the landlord, so you kind of know how much you can push back and sort of what position you want to take.
Yeah. But one final question that's come up, Rhys, is what if you're in a sublease situation where you're not negotiating with the landlord directly, even if it may be an informal sublease situation, and the entity you're subleasing from refuses to engage with the head landlord about relief? What would you suggest in that scenario where you want to apply for it, but the person you're subleasing off won't engage with the landlord?
It's a really interesting scenario if you're if it's an informal arrangement. You're kind of a little bit stuck, because you haven't got there's nothing there that requires them to enforce the terms of the lease. But if it's sort of a documented sublease, I would expect to see a term in that document that requires the head lessor, or the landlord that you're leasing off to enforce their rights under the head lease, and one of their rights would be for that rent relief. So you could certainly push them on that and require them to do that. Otherwise, it would be a breach of a sublease. But if it's informal, again, you got to sort of appeal to the moral conscience. I think that's probably the best you can do.
Great. Hey, thanks so much, Rhys. You've been superb today. I know this is going to be really valuable to a lot of people. If somebody wants to reach out to you, they can jump on the Gibson Sheat website, and you're pretty easy to find. You're based in Lower Hutt most of the time, and certainly all of the time right now. But online support's obviously available to anybody that needs it, right?
That's right, and we've got a page on our website which just deals with COVID-19 issues. Right. So there's construction, there's employment articles, there's lease articles, there's all sorts of things, even just things about when we went into lockdown last year, we did a SWOT analysis for our business on what do we do next, how do we position ourselves. So just I just encourage people to read those sort of articles, and obviously articles that you guys feed through as well.
Yeah, good. That's awesome. Hey, thank you so much, Rhys. We'll be back with some more live streams next week. Stick around on our Facebook page to find out what they're going to be. Stay strong out there. Stay safe. Fingers crossed we get some good news this afternoon, and we get back into a better version of normal soon. Thanks, everyone. We'll talk soon. Bye.